Hello, this is John Milburn, part of the Environmental Law series. We're into week 8. We're dealing with protection of biodiversity and climate change. And we cover an enormous part of the Bates textbook this week, chapters 12 to 18 inclusive. Now, very importantly, certainly from my perspective, soon you'll have an opportunity to provide feedback. That feedback is important to me, it's important to the university. So when you see that big red button turn up on the Moodle site, please have your say, and I'd certainly appreciate it. Tonight, we're dealing with the manner in which government provides for the protection of biodiversity and climate change. And I use the term government purposely because the environmental assessments that we've been discussing in the last couple of weeks and the mechanisms that are put in place to protect biodiversity and climate change are governed by government process. So you'll remember that decision making to do with environmental management is catered for at 3 different levels to reflect our separation of powers. So Parliament, of course, is involved in making the formal statement of environmental values and policies in legislation and regulations. And that legislation provides, if you like, the strategic framework for environmental management and provides a set of rules to support government policy. The second level, government, which is primarily what we'll be talking about tonight, is something which, in conjunction with interested parties, provides an opportunity for the implementation of the plans and programs that are relevant to environmental management. And that regulation mainly determines decision-making process. And individual regulators or assessment managers, as we talked about last week, apply that process in a week-by-week, case-by-case situation. The third level is courts, and it's not for the courts to determine policy. It's not for the courts to deal with individual matters at first instance. The court's role is to deal with judicial review and, in some instances, merits review matters. And we'll talk a little bit more about that throughout the rest of the course. So of the 3 levels of, if you like, government, tonight we're talking about the second level, which is government. And that's the executive level. And of course, we're dealing with the executive level or government, both in the federal sphere and the state sphere. Now, the EPBCA provides for strategic assessment at a federal level, but there is something that we touched on last week in the context of controlled actions, and that is the issue of the discretion of the minister at a federal level to make assessments, so that is part of government process, but done in a way where the minister has a great deal of discretion. So tonight we're talking about biodiversity, we're talking about climate change, we're talking about protection matters, and most of that is done through regulation. And the way in which we approach it is to consider the resource management at a state level, at a federal level, and also privately. So let's have a look at those. At a state level, we're really talking about the conservation of nature. Now, we've only got 1 participant tonight, so I won't pick on you too much, John, but feel free to jump in and ask questions or make comments. At a state level in Queensland, it will come as no surprise when I say that the legislation that primarily deals with the conservation of nature is the Nature Conservation Act, 1992. And it provides for regulations to give effect to the management and conservation plans and enforcement compliance issues in relation to the management and conservation plans. So that's the most important piece of legislation when it comes to protection of biodiversity and nature conservation in Queensland at a state level. Now, the regulations which are promulgated pursuant to that Act give effect to that management. And one of the important ways that management of natural resources is implemented and supported in Queensland is through conservation plans. And conservation plans can be subordinate legislation, delegated legislation. We talked about that in week 1 or week 2. So a management plan or a conservation plan, which is part of subordinate legislation, doesn't have full effect until it's approved by the Governor in Council. Have a look at sections 119 and 123 of the Nature Conservation Act, and that will give you an idea of how this works in practice. Now, here's a key point. Once the conservation plan is implemented, it's been approved by Governor in Council, it becomes part of our law as subordinate legislation. It has, if you like, elevated status, given that it's part of our subordinate legislation. And flowing from that, there is a duty on local governments not to make decisions about the use or development of land that are inconsistent with the regulation giving effect to that plan itself. If you're arguing a position as a developer, a proponent, or as an objector, then look carefully at any conservation plan because it has this elevated status as subordinate legislation. And if you don't like what you see, then you can argue the case against the decision maker based on their own documentation, if you like. Okay, so that's a state level, Queensland only. Federal, dealing with the Commonwealth implementation of plans. Again, we're thinking federal, so we always think EPBCA, the Environment Protection and Biodiversity Conservation Act. No surprise that when we're talking about the protection of biodiversity, that we look at the EPBCA because it's actually written into the name of the Act itself. So the EPBCA at a federal level provides for the preparation of plans of management for parks and reserves, and it does this in 2 ways. The first is, I suppose, if you like, non-geographic, non-physical location. So the EPBCA provides for the conservation of biodiversity more at a global level where, and I'll use a phrase that's used in the Act, and it's a useful one to have up your sleeve. It's called the values of nature. So the values of nature are protected under the EPBCA in a global sense. Now, the second way that the EPBCA provides for the conservation of biodiversity is in relation to geographic issues, specifically where, again, we're talking about the protection of the values of nature, where that's an element of the management of areas within the Commonwealth jurisdiction, whether that's on land or marine, or set aside as a Commonwealth reserve. So how does this work in practice? We'll have a look at section 176 of the EPBCA, and you'll see there that the Commonwealth is able to prepare bioregional plans for bioregions within the Commonwealth area. And the Commonwealth is under a duty to implement a plan to the extent that the plan applies in that Commonwealth area. Have a look at section 269, subsection 1 of the Act. So the EPBCA enables the Commonwealth area to be a conservation zone so that biodiversity in that area may be protected while being assessed for inclusion in a Commonwealth reserve. So you'll see that a conservation zone is, if you like, in many ways a precursor for something that will go into a Commonwealth reserve at a later time. So are there any special areas? Well, yes. Make sure you consider World Heritage areas. I think Great Barrier Reef Marine Park, which has its own legislation from 1975, and that provides for the establishment of the Great Barrier Reef Marine Park Authority. And that's got a duty to prepare a zoning plan for the area. So far we've talked about the duties imposed on government at that second level, executive level, both federal and state, in relation to protection of biodiversity and some of the overarching uses or techniques used in that regard. I mentioned that there's a third level, and the third level is private. So a project plan will itself involve, in many instances, the planning for internal purposes within that plan, and it must be done in a way as to ensure compliance with legal requirements. And all of this won't come as a surprise given our discussions last week. All of this is regulated primarily through environmental impact assessment processes. Okay, so that's the overall structure. They're the pieces of legislation that you need to look at, the specific sections that provide you with some guidance in terms of government ability to deal with protection issues. Let's get down to the nuts and bolts. How is this implemented in the context of a planning development application? Well, you remember that Bates, I like this phrase, Bates said something to the effect that regulation is at the heart of environmental law practice. And at the heart of that is environmental offsets. And environmental offsets is a framework. It consists of an act, regulations and policies, and I'm talking now in the Queensland context. So in Queensland, specifically, the environmental offset framework includes, well, this won't come as a surprise, the Environmental Offsets Act. It's 2014. It's been amended and it coordinates the delivery of environmental offsets across jurisdictions, and it's, if you like, the single point of reference in terms of legislation. Now that legislation is supplemented by the Environmental Offsets Regulations of 2014, and finally the Environmental Offsets Policy, which is really important. And it's possible for you to look at each one of these provisions, each one of these pieces of material, again, to support a particular argument that you might have or argue against a certain proposal based on what's contained in that. I'm going to share the screen. I want to look at 3 sections only of the Environmental Offsets Act. Please bear with me while I do this process. I'll call up the Act. The sections, if you're following along, are sections 3, 7 and 8 are the ones that I want to look at. You should now hopefully see a copy of the Act. Try to make that a bit bigger. All right, so the Environmental Offsets Act of 2014. As always, when looking at a piece of legislation, I look at the contents, I look at the headings, and I take note of what are in these parts and various divisions. It's really important that you get an overall feel for the Act, because every section that you read must be read in the context of the Act as a whole. I'm not saying you have to read every word, but you need to have a better idea of the overall context and what the Act is seeking to achieve. Now, I teach statutory interpretation in the law school, so one of the things that I encourage law students to do is look at some of the big ticket items to determine what this Act is all about. One of them is the long title, and you'll see that there, an Act to provide for environmental offsets to counterbalance significant residential impacts of particular activities on particular matters of national, state or local government significance, and to establish a framework in relation to environmental offsets. So the 2 things there, using offsets to counterbalance significant impacts of an activity and to establish the framework. The long title is supplemented by the purpose or objects of the Act. And in this case, this is the first of the 3 sections I want to bring to your attention. Section 3 outlines the purpose of the legislation. And as we often see, the purpose or the object of the Act is often a restatement, albeit in an extended form, of the long title to the Act. So here we see that, again, the 2 purposes, the first purpose, number 1, which is the main purpose, to counterbalance the significant residential impacts, and the secondary purpose, which is subsection 2, to establish the framework and do so by recognising and providing and coordinating certain things. The second section I want to bring to your attention is Section 7. Section 7 provides for key concepts and definitions. So what is an offset condition? What is an environmental offset? What does a prescribed activity require? An environmental offset is an activity undertaken to counterbalance the significant residential impact of a prescribed activity on a prescribed environmental matter. That wording is very familiar because that's the wording that roughly corresponds with the main purpose of the Act. So arguably, Section 7, defining what is an offset, and subsection 2, providing specifically what it is at the heart of the legislation. And Section 8 deals with the wording of what is a significant residential impact, because you'll recall that the main purpose of the Act is to provide a counterbalance against a significant residential impact on a prescribed activity. So Section 8 tells us how we go about determining whether something is or is not a significant residential impact. So have a look at that and you'll see, of course, reference to the Nature Conservation Act, which is hardly surprising. The Act does go on to talk about what is a prescribed activity. So keep that one in mind. Now, while I'm sharing the screen, I'm going to show you the environmental offsets regulations, and hopefully that will come up on the screen shortly. So when you're looking at an Act of Parliament, it's always a good idea to look at the regulations. And if you don't know where to find these things, there's a few places. I'm looking at the authorised reports now. You'll see that I've drawn them from legislation. And I've just obscured legislation.qld.gov.au. Another good place to look is AUSTLI, AUSTLII. So here we have the regulations, and that provides for the practical implementation of what we're talking about. And for example, when we looked at the Act itself, I mentioned briefly Section 9 provides for prescribed activities. Section 10 talks about prescribed environmental matters. And here in the regulations, the detail is fleshed out a little more. Now, probably the most important place to look, and the best resource for you, is the policy. I mentioned the Queensland Environmental Offsets Policy. It's 2016 is the current version, which is version 1.2. We'll see if we can call that up on the screen. And it came into effect on the 1st of July 2016. What it did in this current version is reflect protected area categories under the Native Conservation Act, which was amended on the 1st of July 2016. So this environmental offsets policy is a great resource document. I'd urge you to flick through it, get a feel for it, get an idea of how this is implemented in practice. You'll see calculation data selection and data tables, and I'll just show you a pretty cool little device that is available on the website in relation to the calculation of these offsets. Okay, so it talks about the purpose, it talks about the principles, what are the prescribed environmental matters. You'll remember that when we looked at the regulations, and it provides for not only the type of offset, but the delivery of the offset and the issues to do with the calculation methodology of the offsets, which is in 4.3. Okay, so that's in conjunction with the Act and the regulations. That policy document is the Bible. So when and why do we have an environmental offset? Well, it might be required, probably typically would be required, as a condition of an approval. So when the assessment manager considers a particular proposal, it will consider avoidance or mitigation measures in relation to a prescribed activity, and if it's likely to result in a significant residential impact on a prescribed environmental matter, then the environmental offsets regime comes into place. An offset...
Sorry.
Yes, John?
Sorry, John. It takes me back to your guest presenter of a couple of weeks ago who talked about the Paradise Dam case.
Yes.
He was saying, well, the alternative was, what were they going to do? Offset the Burnett River.
Yeah, exactly.
And of course, you offset the whole river.
Yes, that's right. And there's no doubt that that would have been significant, but how do you quantify that type of enormous offset? No, I agree with that. Thank you, John. All right, so what I want to do now is just show you what's called a financial settlement offset calculator. You'll find this on the website, and I'll bring it up on the other screen. I'll just share the screen now. Okay, so here we have Queensland Government, an offset calculator, and it's to perform an offset calculation. If you do that, you must be familiar with the new environmental offsets framework. Well, we've had a look at that, and in particular, the meaning of a section and a distinct matter area as outlined in the environmental offsets policy. Well, we've looked at that as well. Okay, so what would you like to calculate? A financial settlement. Let's try that. Now, I don't know if this will work, but we'll see. So it's basically some check boxes. We're looking at terrestrial or marine. Let's go terrestrial. If terrestrial, select the local government area. Let's go Cairns. Probably a bit of activity there. All right, confirm the selection. It will then go into asking some further material. So let's assume it's wet topics at Mellon and Kerr. And the area, we'll go with 5 hectares. The matter group, we'll go with threatened plants. The species, we'll go with any. I'm not sure if that'll work, but we'll try it. No, I think it wants me to give an answer. We'll go with wattle. Now, people that actually know plants will be saying that's not going to be a threatened plant in that area. I apologise for that. All right, so, and it's looping on me now. And no, and it couldn't be calculated because it didn't happen in that area. So you'd think I would have actually considered and had one mapped out, which I did. When I did this exercise before, I just selected things at random and it came up with some huge dollar figures that were really interesting. So I'll just try it one more time. But you'll see the extent of work that's gone into setting up this calculator to deal with very specific issues.
John.
Yes, John?
It all seems like an excuse to be able to do some environmental damage and get away with it.
Look, that's a really useful statement because that's a
technical statement. Yes.
Yeah. No, but it's one of the main arguments. People argue that we shouldn't have an offsets regime at all because it's buying your way into a certain situation. That's not the intent, of course, but that's what is perceived to be the case. And it's that balancing of, if we go back to the definition of ecologically sustainable development, Section 8 of the Sustainable Planning Act, we have to consider both the economic and the social, as well as the environmental. Okay, so having failed to actually show you a financial settlement, I'd urge you as an exercise to go into that calculator and go through the exercise and see if you can come up with some figures, because you'll be surprised at the dollar figures can be quite substantial in that regard. Now, in terms of the Commonwealth, there are Commonwealth Marine Reserves. They're administered through the Department of Environment and Energy. And of course, the EPBCA provides for the proclamation and management of those reserves. And the Director of National Parks is a statutory authority responsible for administering and controlling those reserves under the EPBCA. I've already mentioned the Great Barrier Reef has its own act and has its own authority. The other ones that you might want to consider are Ramsar wetlands. You'll see that mentioned a lot. And the Convention of Wetlands of international importance was called the Ramsar Convention. And essentially it provides for a framework for the conservation and wise use of wetlands and resources. So it's an international organisation, Ramsar. And Google that, have a look at the website for the Secretariat, because it supports the parties to the convention. It's a very substantial thing. Now, I mentioned conservation agreements before, and at a Commonwealth level, these conservation agreements are not only entered into, but they're made public. So you can Google a list of conservation agreements under the EPBCA, and they're very specific. They, such as the management and protection of EPBCA threatened species. For example, let's have a look at some. Actually, I'll share the screen. Rather than talk about it, I'd rather show you these things. All right, so hopefully you can now see the list of Commonwealth Government conservation agreements, or at least the web page for those agreements. And you'll see a list of those agreements under the EPBCA. So one of them is in Queensland, and it's close to my area here at Hervey Bay. And it's to do with the management and ongoing protection of EPBCA listed threatened species, a translocated population of Quassia bidwilli at Hervey Bay. And that's on Maggs Hill Road, which is not far from where I live. Okay, so you can see those conservation agreements on that website. Now, here's an important point, particularly if you're involved in conveyancing. Those conservation agreements are binding not only on the person who entered into the agreement, but also successors of the interest. So anyone who acquires an interest subject to that acquires the conservation agreement as well. And if you want to enforce an agreement such as that, you can do so by application for an injunction in the federal court. Have a look at section 476. And have a look at actually in week 11, I think, we're going to highlight how you actually do this in practice. And I think I've selected the Flying Fox case in that regard. Okay, so some really interesting things on the website there. I'll just stop that share. So we've been looking at conservation agreements, a list of them on the federal website. Remember, of course, that from the state perspective, under the Nature Conservation Act in Queensland, there are state protected areas, and the Act declares that the object of nature conservation is achieved by integrating and comprehensively conserving nature by reference to a strategy. And that strategy involves protection of areas of biological diversity, natural features and wilderness. And also in Queensland, we have marine reserves as well. But remember, of course, that when it comes to marine reserves, the Commonwealth has constitutional sovereignty over all of our coastal waters. However, the federal government and the states entered into what we call a constitutional settlement. And effectively what that means in practice is this. The Commonwealth reserves are from 3 to 200 nautical miles from the coastline, and that leaves by default the area of 3 nautical miles from the coastline for the states. So in Queensland, we have the Marine Parks Act 2004. We also have the Fisheries Act, and both of those are relevant for providing some statement as to management and protection in relation to the coastal areas, fish habitats, issues to do with pollution, restoration, works controls, etc. And all of that is governed by management plans at a state level. Well, remember, of course, that when we talk about these things and we set up these frameworks, that they are capable of being attacked through enforcement orders. I mentioned briefly the use in a federal sphere of the injunctive relief available under Section 476. In a state sphere, remedial orders are available as well, and criminal prosecutions are not uncommon. And the penalties for criminal prosecutions can be very substantial. The other thing that you need to consider is the nature of the native vegetation framework that's administered by the Department of Environment and Energy. And that's where there is some regulation set up. In Queensland, we have the Vegetation Management Act of 1999. That was amended a few years ago, and it's always been a hot topic of discussion. But have a look at the Queensland website, because that will have some valuable information in relation to provide clearing activities as well. So I won't show you that website now, but it is something worthwhile having a look at. Okay, so when it comes to native wild... Yes, John?
The Labor government needs a working majority to pass the legislation to stop the tree clearing.
Yes.
Because the LNP...
Well, I get, without becoming too political about it, it is a source of fundamental divide between the policies of the government. No, I agree with that.
It's a tragedy they allow it to just keep happening. I mean, all the bush on the other side of the Great Barrier Reef, they just think, well, we'll just clear whatever we like and turn into cattle feed. I mean, a few multinational corporations making some bucks, and they're just destroying whatever they can before the legislation's changed.
Yeah. Again, I've got to be careful. I can't go into too much comment, but I'm sure you understand. But there are significant penalties. And if you look at, say, the Minister for Environment, Heritage and the Arts against Lamantina, which is a federal case, 2009 Federal Court of Australia 753. In that case, the respondent was ordered to pay $220,000 for clearing native vegetation. In De Bono's case, 2012 Federal Court of Australia 643, the penalty was $150,000.
So John, why are those tree clearing cases in Queensland? Doesn't the Commonwealth Act under the EPBCA on biodiversity, etc., and actually be able to say you can't do that?
Yeah, well, have a look at section 194Q of the EPBCA. That provides for a restriction on people taking certain action, and it also then provides for civil penalties. So the penalties can range from $550,000 for individuals up to $5.5 million for corporations. That's based on what the current penalty rate is. Mind you, I don't think we'll ever see anything up near those figures.
Does anybody ever get that? Does anybody
No.
ever pay that price?
No.
I mean, it could happen, but there's a penalty maybe, but does it actually happen?
Yeah, well, again, I mentioned that the maximum 550. In the Lamantina case, it was 220. I mean, I guess we mentioned that because it's right up there in terms of a penalty. But no, it's rare, short of murder, it's rare that you ever see the maximum penalty imposed in any form of prosecution. And that's no different in environmental prosecutions as well.
And there's probably very few prosecutions.
Well, prosecution is probably a last resort. There are many other different ways that regulators can go about dealing with transgressions, and you know, that might be an exam hint too. In terms of, I'm always interested to know how people might consider going about and using the different options that might be available to them if they're trying to pursue something, if they're trying to regulate for something. All right, so
that was an exam hint?
a little bit. It was pretty obscure, wasn't it?
Very bloody obscure.
Well, I'll be a little bit more detailed. If someone doesn't comply with the condition, then the question always is, well, what happens now? So maybe that's a bit more of a hint. Okay, I mentioned the Nature Conservation Act in Queensland. The Department of Environment and Heritage Protection is responsible for administering that act, and it does that through the protection of wildlife and ecosystems. Pollution control is also relevant. Now, it won't come as a surprise when I mention that pollution control in Queensland is dealt with by the Environmental Protection Act. And I think I've mentioned this before, Section 17 is important because that's the definition of serious environmental harm. And again, there are definitions as to how that comes about. You might recall that the threshold amount is $50,000, or it can be greater by regulation. I'm going to just show you a case which I thought was interesting. It's a recent case. I will share the screen. It's called Bergen, B-E-R-G-I-N, against Link Energy. And I'm trying on my tiny little computer to get to the buttons I need, which I've now done. All right, so this is Magistrates Court. We don't see many cases reported from the Magistrates Court sphere, but this was an interesting one where there were QCs on both sides arguing in relation to a prosecution. So coming back to what you were saying, John, about whether they happen, well, they do. This is one where the magistrate was asked to determine whether there was sufficient evidence to warrant the defendant being committed to the district court for trial with respect to a charge brought against him pursuant to Section 17 of the Environmental Protection Act. And in this case, the magistrate determined that the extent of the nature of the alleged harm to the environment was sufficient to justify the defendant being committed to the district court. There was enough evidence to satisfy the threshold test. Now, the threshold test is whether any jury could reasonably come to a decision of convicting a person. So that's an interesting little case to consider. It deals with the Environmental Protection Act. It deals with what is involved in prosecuting, what are the threshold amounts, and how is that considered in the context of the serious environmental harm. And
sorry, John.
Yes, John.
In effect, the offence was blatant and he had no defence.
No, okay, I couldn't say that because I must confess I haven't followed through to see what ultimately happened in this case. But what we've got here is a note that at the committal stage, the magistrate was of the view that there was enough evidence to put the defendant on trial for the charges, and that's the basic test. So that's Bergen against Link. Just again, yes, John.
What happened in the district court?
Actually, that's where I haven't followed through, but it was very recent, Bergen, so I think it was only last year, and it may not have gone through the district court yet, but sometimes you don't find out because it may not be a reported decision. So, you know, so there is that issue as well. Look, here's another one that I thought I'd bring to your attention. Crowther against the State of Queensland. You'll see it's a Planning and Environment Court case from 2002, and that's number 79. So in this case, the applicant brought a declaration, sought to restrain an offence alleged to have been committed against the Environmental Protection Act and did so by bringing an application to the P&E Court pursuant to Section 505 of the legislation. So if you want, sorry, John. No, you're right. So if you're wondering how you might go about enforcing issues to do with, in this case, odours emanating from a foundry and metalworking processes that were alleged to have unreasonably interfered with environmental values, then keep in mind Section 17, which deals of the EPA, which deals with serious environmental harm, but consider Section 505, which provides an opportunity for the prosecution of the matter. And you'll see there that the application was treated as brought under Section 505, which provides an opportunity for the court to remedy or restrain an offence against the Act or a threatened or anticipated offence against the Act by using that section as the basis upon which to proceed. So proceedings can be brought in the court for an order to remedy or restrain an offence against the Environmental Protection Act by someone whose interests are affected by the subject matter of the proceeding, or someone else with leave of the court, even though they don't have a proprietary, financial or special interest in the subject matter. So that's what Section 5, there it is. So that's the part that I've just read.
However, John, this concerns a case where the damage has already been done, correct?
Not necessarily, because Section 505 subsection 1 provides an opportunity for a person to seek to remedy or restrain an offence or a threatened or anticipated offence. And later in the course, we'll talk about some instances where people have actually done that. In fact, this one is a really good example, because in this case, Crowther, I think it's Dr. Crowther, successfully sought a declaration that airborne emissions generated from the Yeronga TAFE amounted to environmental nuisance. So Claire Crowther took on the state government in a state court to say the emissions coming from your Yeronga TAFE amount to an environmental nuisance. And the order that was made by the court was to restrain the respondent, which is the state of Queensland, from allowing that environmental nuisance to continue. Let's have a look at paragraph 28 of Judge Robin's decision.
That ruling could cover a lot of things.
Oh, look, it could.
I mean, environmental nuisance, it could be noise, what else? Poison.
Yes. Oh, yeah. Yeah, absolutely. No, there's plenty to it. Things that could certainly be considered. So Judge Robin found that in that case, the environment was broadly defined, which is your point, John. It can be very broadly defined. And in that instance, the court said that the absence of unpleasant odour does relate to quality of place and therefore the environment. It's an environmental value for the purposes of Section 9. So unreasonable interference in causing that nuisance is something that can be restrained. And the court said, look, what's important here is what is unreasonable. And what is unreasonable is a matter to be decided by reference to each case. But in this instance, the court said that it was sufficient to justify an order.
A point,
yes, John?
I'm sure there'd be a qualification where an area was zoned a particular way, like an industrial zone or something, where they could completely get away with it.
Look, I think that's absolutely right. The context is really important as well. And what is being done where is critically important. Have a look at paragraph 38 of the judgment. It says, it is for the respondent, which is the state government, to avoid trouble under section 438 by showing the general environmental duty has been complied with. And the sporadic steps taken so far, in my view, have been ineffective, and those proposed from the point of view of making the court order unnecessary seem unlikely to be effective. So I really like this case because it does show a number of things. It shows that the Act, the Environmental Protection Act, binds the Crown. You'll see that specifically stated in paragraph 40, referring to section 22 of the Act. And while it's unusual, says the court, to contemplate an injunction against the state government, counsel conceded that one may be ordered, pursuant having regard to the Crown Proceedings Act. All right, so in paragraph 41, the case also talks about the onus of proof, and it talks about the Environmental Protection Act not being particularly helpful in that regard, but it does provide some useful detail, not only as to who bears the onus of proof, but what is the standard of proof. And in this case, the court decided that it should be on the balance of probabilities. But the court said that even if we did apply the standard of proof beyond reasonable doubt, the court is satisfied that there have been offences committed in this instance. And that's at paragraph 41. Sorry, moving around there. Okay, so have a look at that case and I'll come back to the screen. So that's essentially all that I plan to talk about tonight.
Thank goodness.
I know, it's been a long night. You've done well, John.
There's so much more information in these sessions than there is in everything else.
Yeah.
Like, this should be the lecture, and the other stuff is the supporting stuff.
Yeah, and I think I've mentioned here in the past, ideally, if we have a class of, even 10 people, it becomes much more like a tutorial. But, I can't just keep asking you questions all the time, John. That wouldn't be very fair.
Yeah, but you have too much information to give to be asking questions. And so this is like the lecture.
That's
true.
And
the other stuff is more the backup. This should be what the students should be watching. And and as I've said before, to make them do it, you need to have the participation graded. Otherwise, students do not do it.
Yeah, I know. And you've counselled me about that previously.
Absolutely.
Yeah, no, I hear what you say. All right. But yeah, look, and also I guess it's fair to say that I can provide a lot less information in these sessions, or I could provide a lot more, but it's a matter of tailoring it to suit, I guess.
The thing is, you're probably used to teaching people that are going to law for a living.
A little bit.
An environmental science student, this is just a subject that I have to take, and even though it's very interesting, it's not something that I'm going to be telling people I'm an expert at. Yeah. You know what I mean?
I know what you mean. Yep.
You know what I mean?
And I teach environmental law to the law students as well. And I do try not to be as technical when I'm doing this subject as I am with the other subject, where we're dealing with the forms and the practice directions and the regulations and in more detail. But yeah, you're right. I've got to be careful not to go into it too legalistically.
Well, it's really a hell of a crash course in law for someone that's never touched it.
Yeah, that's true. That's true. But you've done well. Everyone's done well so far from what I've seen. And I think the assessment is due tonight, isn't it? I take it your assessment's in?
What assessment? Is there an assessment, Jude? What assessment? No one told me.
It's only about 10 reminders. All right.
No, I have contributed some kind of effort.
Very good. Thank you.
I'm not really happy with it, but it's all things considered, it's what I could come up with.
It is what it is. All right. Well, thank you very much for participating, John. I'll end the session now, and we'll see you next week. All the best.